individuals from certain majority Muslim countries, and her stance was then vindicated by the Ninth Circuit. Second, instead of taking strong stands to protect the voting rights and civil rights of all, the department has taken steps to further erode those rights. Specifically, we already see the Civil Rights Division switching positions in important cases like the Texas voter identification law, or withdrawing its guidance relating to transgender students. This reversal of course, away from policies that uphold and protect civil rights for all Americans, is unfortunate, but it well may reveal the intended path of the future. Over the past several weeks, there have been numerous press stories about the White House attempting to direct communications for ongoing investigations and even direct U.S. attorneys on how to argue cases. I continue to strongly believe that the case can be made for an independent investigation that is insulated from any potential political influence. So I very much support the appointment of a special prosecutor to lead the investigation into Russian influence in the election. I believe we need an independent criminal investigation into Russian influence. It's vitally important that the American people have trust in this investigation and that there is not even the appearance of a conflict of interest or political influence. So that's why I continue to support the appointment of a special prosecutor to lead the investigation. To be clear, I do not say this because I question the integrity or the ability of Mr. Rosenstein. I do not. But this is about more than just one individual. This is about the integrity of the process and the public's faith in our institutions of justice. Justice Department regulations clearly provide for the appointment of a special counsel when there is a conflict of interest for the department or other extraordinary circumstances, and where the appointment of a special counsel would be in the public interest. By his own words, Attorney General Sessions was a surrogate for the Trump campaign. He has admitted he met with the Russian ambassador on 2 occasions. And on Friday, the Attorney General announced he believes he should recuse himself, and he has. In addition, the investigation into Russia's interference could very well involve officials in the Trump administration. All these factors demonstrate that there is, at the minimum, an appearance of a conflict of interest, which is what's needed under the regulations. In addition, if you look back to December 2003, when Attorney General Ashcroft recused himself from the Valerie Plame case, that very same day, then Deputy Attorney General Comey appointed a special prosecutor. He said he did so out of an abundance of caution and to avoid any appearance of a conflict of interest. I believe the same abundance of caution is warranted here. As has been done in the past, a special prosecutor should lead this investigation. I believe it should be a respected prosecutor, someone free of any partisan or political background, someone who has a reputation for integrity and impartial decision-making, and who is independently selected, not by the Attorney General. From the outset, we need a respected prosecutor who was independently selected, free of any partisan or political background. I'm also concerned about the Justice Department's role in dismantling important rules and regulations that, among other things, help protect consumers, keep people safe, and protect our environment. Through executive orders and congressional repeals, President Trump and his allies are taking unprecedented steps to help big business but harm average Americans. I've had an opportunity to meet with both Mr. Rosenstein and Mr. Brand, as I said. They both have impressive credentials, and I enjoyed meeting with them. But as we all know, the test of leadership and suitability for a job is not how nice you are or how well you get along. It is whether the Justice Department or our courts, whether in those departments we need independent, fair-minded public servants who will adhere to the rule of law and look out for everyone in this country, not just the powerful or well-connected. We need steel spines, not weak knees, when it comes to political independence in the Department of Justice. And there is a real danger, I believe, that the Justice Department could become politicized. And so I hope to hear today from these nominees what they will do to guard against just that. Thank you very much, Mr. Chairman.
Thank you, Senator Feinstein. Now Senator Ernst, and then Senator Cardin, and then Senator Van Hollen.
Thank you, Chairman Grassley. It is my privilege to be here today to introduce a native Iowan, Rachel Brand, who has been nominated to be Associate Attorney General of the United States. After graduating from Pella Christian High School in Pella, Iowa, and the University of Minnesota Morris, Ms. Brand went on to receive her law degree from Harvard Law School. After law school, Ms. Brand embarked on an impressive legal career in both private practice and public practice. In fact, she has at one time or another served in all three branches of government. She was previously confirmed by the Senate as Assistant Attorney General for Legal Policy at the Department of Justice, and before that, she clerked for Justice Kennedy on the Supreme Court of the United States. And perhaps the most prestigious of all, she worked as an intern for Senator Grassley. In addition to her public service, Ms. Brand has had a distinguished career in private practice, has taught as an adjunct law professor, and serves as a board member for Doorways for Women and Families, an organization dedicated to creating pathways out of homelessness, domestic violence, and sexual assault. Ms. Brand has shown time and time again a commitment to public service, and if she is confirmed, it is my understanding that she will be the first woman to serve the country as Associate Attorney General of the United States. I am honored to be here today to support her for this position, and I look forward to what I hope will be a speedy approval of her nomination. Thank you, Chairman Grassley.
Thank you, Senator Ernst. Now Senator Cardin.
Thank you, Senator Grassley, Senator Feinstein. It's a pleasure to be back before the Judiciary Committee. I thank you for this opportunity. I first want to thank both of our nominees for being willing to serve their country, and thank their families, because this is a family sacrifice to serve in government, and we thank them for being willing to do this. I'm pleased to be here with Senator Van Hollen to introduce and support Rod Rosenstein to be the Deputy Attorney General. This was a welcomed nomination by President Trump. Rod Rosenstein has demonstrated throughout his long career the highest standards of professionalism. He has dedicated his entire professional career to public service. He's an experienced prosecutor and administrator. Very impressive credentials, graduating from the University of Pennsylvania Wharton School, from Harvard Law School, where he was editor of the Harvard Law Journal. He was clerked for Judge Ginsburg on the District Court of Appeals. He's been the U.S. Attorney since 2005. He has served in many leadership positions among the U.S. attorneys, and as Chairman Grassley pointed out, he's been given very sensitive assignments by the Department of Justice because of his known professionalism. I am very impressed by his responsibilities as a U.S. Attorney for the state of Maryland. He has led major criminal investigations and prosecutions in regards to contraband smuggling with gang members, inmates, and correctional officers. He has personally supervised the coordination of our anti-terrorism efforts, recognizing that each stakeholder can add to the strength of Maryland's efforts to fight terrorism. He's done that without regard to turf issues, providing a coordinated strategy in our state of Maryland. He has handled corruption cases, sensitive corruption cases, from police officers to elected officials, and he has protected Maryland citizens through his commitment on consumer issues and on environmental issues. What impresses me the most is the fact that he has done this in a totally nonpartisan, professional manner. When I was elected in 2006 to the United States Senate, Rod Rosenstein was already the U.S. Attorney. He had been appointed there by President Bush. So I first met Mr. Rosenstein when he was U.S. Attorney for our state. And when I was elected, I was approached by many elected officials as to what was going to happen with the U.S. Attorney. I was impressed by the first phone calls I received from the law enforcement individuals in Baltimore City responsible for the protection of our city, all urging me to encourage President Obama to retain Rod Rosenstein as U.S. Attorney. That was not the only call that I had received. He has received strong support from the justice leadership in the state of Maryland. State and local officials strongly support his appointment to the Deputy Attorney General, strongly supported his work as U.S. Attorney. So when Senator Mikulski and I had to make a decision, we recommended to President Obama that he retain Rod Rosenstein as the U.S. Attorney for Maryland, and we're pleased that President Obama did, in fact, retain Mr. Rosenstein as our U.S. Attorney. He has the support of state and local officials. Brian Frost, the Attorney General of Maryland, supports this nomination. Doug Gansler, the former Attorney General of Maryland, supports the nomination. Peter Franchot, the Controller of our state, Greg Bernstein, the former State's Attorney of Baltimore City, all support Mr. Rosenstein because of his record and his professionalism. He's supported by our local police. Kevin Davis, the Chief of Police for Baltimore City, supports this nomination. And as you may know, Baltimore is under a consent decree as a result of a pattern and practice investigation in Baltimore. The Maryland State Bar Association supports his nomination. Former Assistant U.S. Attorneys support his nomination. Mr. Chairman, I think Mr. Rosenstein is the right person at the right time for Deputy Attorney General. I share the concern of many members of this committee as to what Russia did in attacking our democratic institutions. I support a complete investigation to understand exactly what happened. I believe the facts need to be done by an independent commission, and that would be the best way for us to get all the facts necessary in regards to what Russia was doing. The Attorney General's office must follow the facts, including the standards for the use of a special prosecutor. Based on Mr. Rosenstein's prior record, I am confident of his judgment on these issues.
Thank you, Senator Cardin. Now, Senator Van Hollen.
Thank you, Chairman Grassley, Ranking Member Feinstein, members of the committee, for the opportunity to join Senator Cardin in supporting Rod Rosenstein's nomination to become Deputy Attorney General. As you've heard, he's had an illustrious and long career, and during his 27-year career, he's earned a reputation as a fair and focused administrator of justice. As a result, he has served in both Republican and Democratic administrations and earned the distinction of being the longest-serving U.S. attorney in the country today. Rod has not only aggressively prosecuted dangerous gangs and criminals in Maryland, but also elected officials who violated the public's trust. He has shown impartiality in these investigations, and his successful prosecutions have led to ethics reforms that increase transparency and public confidence in Maryland. In addition to being a top-notch lawyer, he's known for the professional manner in which he runs his current office. In his letter of support, Maryland's Attorney General Brian Frost notes that Rod, quote, inherited an office in turmoil, unquote, when he became Maryland's U.S. Attorney, but with a, quote, steady hand and superb management, created a department that is now universally respected. Those skills will be put to test in the coming months. It's no secret that Mr. Rosenstein is before this committee at a tumultuous time for the Department of Justice, and his job will be to serve justice and not political leaders. As Rod and I discussed yesterday, the ultimate question is the same one that Senator Sessions posed to Sally Yates during her hearing as the nominee to be Deputy Attorney General, when he said, quote, you have to watch out because people will be asking you to do things you just need to say no about, unquote, and went on to ask, do you think the Attorney General has the responsibility to say no to the President if he asks for something that's improper. Like Sally Yates, Rod Rosenstein said he would be willing to put his job on the line to uphold the public trust and the integrity of the Department of Justice. Mr. Chairman, I share the views expressed by Senator Feinstein and Senator Cardin as to the investigation into any ties between the Trump administration and Russian interference in our elections. I believe they will require the appointment of a special prosecutor, and I've also joined Senator Cardin and others in calling for a nonpartisan independent commission. I also made it clear in my conversations with Mr. Rosenstein that if the FBI director has in fact requested that the Justice Department deny President Trump's unsubstantiated claims about Obama administration's wiretapping of Trump Tower, then the Justice Department has a duty to let the public know the truth. Mr. Chairman, I think we would all agree that it's vitally important that the American public has faith that our laws will apply equally to all Americans, regardless of rank or position. Rod Rosenstein has applied that principle faithfully during his time as U.S. Attorney in Maryland. It's essential that the same principle apply at the Department of Justice. Members of the committee, I do not know what the future holds on these issues of great importance to our democracy. I do know that Rod Rosenstein has a record and reputation of serving justice, and I support his nomination. I also want to join Senator Cardin in expressing our gratitude to his wife, Lisa, his daughters, Julie and Allison, for joining us today, and for their family's commitment to public service. Thank you.
Thanks to both my colleagues, and unless any of my colleagues have questions, you're free to go. Thank you very much. Yeah. Yeah. Oh, I gotta introduce her first. I will take my time now to introduce Rachel Brand, and you've already been told she's a native Iowan. She may not have lived in Iowa for a few years now, but I know she loved going to the Iowa State Fair, and I know that she still goes home fairly regularly to visit a 94-year-old grandmother, and both sets of her grandparents were dairy farmers. Ms. Brand is familiar to this committee. She appeared before us many times, both as a nominee and as expert witness. She has already served the country well, and I'm glad to see that she has been nominated once again, this time as Associate Attorney General. I'll note that this is the third time that she's been nominated for a Senate-confirmed position. Both President Bush and Obama also nominated her for roles in their respective departments or administrations. Before Ms. Brand graduated from Harvard Law School, she was an intern in my D.C. office, as you've been told by my colleague. She clerked for the Justice of the Supreme Court of Massachusetts, as well as for Justice Kennedy on the U.S. Supreme Court. She served as counsel to both President Bush and as Assistant Attorney General, Office of Legal Policy. In that role, she prepared nominees to be sitting at the very place she is at this time. She also specialized in counterterrorism and national security issues. In 2011, she became Chief Counsel for Regulatory Litigation of the U.S. Chamber of Commerce. Most recently, she was a member of the Privacy and Civil Liberties Oversight Board. Of course, that board oversees federal agencies' counterterrorism activities to ensure that privacy and civil liberties are balanced with national security interests. In addition to her vast career accomplishments, Ms. Brand is on the board of an organization called Doorways. Doorways help women and children who find themselves in abusive situations. They have a 24-hour hotline and provide shelter and support services for these people. I'm pleased to support someone who is so well qualified. With her previous positions at the White House, Office of Legal Counsel, Privacy and Civil Liberties Oversight Board, she has experience that touches almost every part of the federal government. As the Assistant Attorney General for the Office of Legal Policy, she was a member of the senior management team of the Department of Justice, working with components and law enforcement agencies across the department. Similarly, at the Privacy and Civil Liberties Oversight Board, she worked with diverse agencies to ensure that privacy and civil liberties are taken into account while carrying out the important mission of protecting the nation from terrorism. And during Ms. Brand's tenure in the private sector, she gained extensive litigation management experience that will serve her well as she oversees civil litigating campaigns. So congratulations on your many accomplishments, Ms. Brand. I'm proud to be able to support your nomination, and I think you'll do a very fantastic job. Will you both now come to the table, and before you sit, I would like to swear you. Do you affirm that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Okay. Now it's up to you, Mr. Rosenstein, to give your statement, but before you do that, you may want to introduce your family and anybody else you want to introduce that's here to urge you on.
Well, thank you, Chairman Grassley, Ranking Member Feinstein, and members of the committee. I want to thank you for scheduling this hearing and thank you for taking the time to meet with me in your offices over the past 2 weeks. I'm very grateful to Senators Cardin and Van Hollen for their generous introductions. I would like to introduce my wife of 22 years, Lisa Barsumian. Lisa is a former Assistant U.S. Attorney who shares my affection for the Department of Justice. She now devotes much of her time to our daughters, Julia and Allison. This hearing, I'm sorry to say, required Allie to break her perfect school attendance record. My older daughter, Julie, writes for the school newspaper, but journalistic ethics preclude her from covering this event today. These young women are excellent students, superb athletes, and fundamentally good people. I'm also proud, Senators, that my parents, Robert and Jerry Rosenstein, are here today. My mom worked as a bookkeeper and served on the school board. My dad ran a small business in Philadelphia with his partner, Miriam Smalls, who's also here. My parents encouraged their children to take full advantage of the promise of America, even when that required us to move far from our small hometown of Lower Moreland, Pennsylvania. My sister, Dr. Nancy Messonnier, also has spent her entire career in public service. She traveled from Georgia, where she is a center director at the Centers for Disease Control. She's also a uniformed officer, a captain of the Public Health Service. I'm disappointed she wasn't permitted to wear her uniform here today, but we're very proud of her. My mother-in-law, Alice Barsumian, flew from California with Lisa's aunt, Rita Arslanian. They are immigrants to America, Senators, and they are quite proud as well to be here today. And many other relatives, friends, and colleagues are in this room or watching the broadcast. Senators, I am so fortunate to be part of one of our nation's crown jewels. The United States Department of Justice stands for the principle that every American deserves equal protection under the rule of law. I want to thank the Attorney General and the President for placing their trust in me to help manage the department and to enforce that principle. The Justice Department has been my professional home for almost 3 decades. I've served under 5 presidents and under 9 attorneys general. And I want to assure you, Senators, based on my personal experience, that our department is filled with exemplary professionals, devoted public servants who conduct independent investigations 365 days a year. I was fortunate to join them in 1990. Then during the Clinton administration, I had the privilege of working directly for the Deputy Attorney General at that time, Philip Hyman. I served in several other positions around the Justice Department, and then in 2005, when I became U.S. Attorney, I expected to serve for 4 years under President Bush. And I am so grateful to President Obama for demonstrating his confidence in me and allowing me to serve for 8 years in his administration with the support of our home state senior senators, Cardin, Mikulski, and Sarbanes. Political affiliation is irrelevant to my work. Our goals of preventing crime and protecting national security require us to work cooperatively with all partners, to be vigilant, and to be proactive. We also need to be role models because contacts with the police create indelible memories for citizens. As Deputy Attorney General, I will draw on my personal experience with thousands of honorable law enforcement officers all around this country as I seek to implement change and to build public trust. Justice is our name, and justice is our mission. Attorney General Robert Jackson famously said that the citizen's safety lies in a prosecutor who tempers zeal with human kindness, seeks the truth, serves the law, and approaches the task with humility. For me, the grand hallways of Main Justice echo with the voices of mentors and friends. They taught me to ask the right questions. First, what can we do? Second, what should we do? And third, how will we explain it? Senators, before taking on a position of this solemn responsibility, it's important to know who you are and what you stand for. My oath is an obligation. It requires me to support and defend the Constitution of the United States, to bear full faith and allegiance to the Constitution, and to well and faithfully discharge the duties of my office. As you know, I've taken that oath a few times. I've administered that oath many times. I know it by heart, I understand what it means, and I intend to honor it. If you confirm my nomination, I will work to defend the integrity and independence of our Justice Department, to protect public safety, to preserve civil rights, to pursue justice, to advance the rule of law, and to promote public confidence. The members of this committee are indispensable partners in achieving those goals, and I know Ms. Brand shares that view, Senators. I am so proud to be here with one of the finest lawyers of my generation, who would become the first female Associate Attorney General in the 40-year history of that office. I want to thank you for allowing me to speak, and thank you for considering my nomination.
Thank you, Mr. Rosenstein. Now, Ms. Brand, and you can give your statement as well as introduce anybody that's here to support you and urge you on.
Thank you, Mr. Chairman. Mr. Chairman, Ranking Member Feinstein, and members of the committee, thank you for the opportunity to appear today as you consider my nomination. I also would like to thank the President and the Attorney General for the opportunity to be considered for this position. I'm grateful to you, Mr. Chairman, and to Senator Ernst for your kind introductions today. Although I have not lived in Iowa in some time, as you mentioned, I will always consider myself an Iowan. I'd now like to introduce my family. With me today is my husband, Jonathan Cohn, whom I met at Harvard Law School, and who is one of the smartest lawyers I've ever known. He also served in the Department of Justice. He was born and raised in Manhattan, and so he was a bit of a novelty the first time I brought him home to Pella, Iowa. And we had some sport with him, taking him around to meet the cows on my uncle's dairy farm, but he took it all in stride and put up with it, and now he enjoys going back to Pella. Sitting with him are our sons, Garrett, age 7, and Willem, age 9. They're not looking too happy to be here, at least Garrett's not. This is the second confirmation hearing that Willem has attended. At my PCLOB confirmation hearing 5 years ago, Willem was 4, and he sat still about as long as could be expected of a 4-year-old until he got fidgety, and Senator Leahy's counsel very nicely asked him if he wanted to go back in the anteroom and gave him something to play with. We didn't think it was wise to bring Garrett, who was then 2, but he was excited to eat cookies and drink juice at my swearing in at Justice Kennedy's chambers. This is the first time he's worn a blazer, and I'm not sure how happy he is about that either, but my parents, Ruth and Ivan Brand, had planned to be here today, but unfortunately their flights were canceled last night and they couldn't make it, but they may be watching the live stream on the website. My mother-in-law, Helena Cohn, is here. She traveled down from New York. Helena immigrated to the U.S. from the Netherlands many years ago, and my kids call her Oma, the Dutch word for grandma. I'm also grateful to the friends who have taken the time to be here today to support me. I have been blessed with opportunities in both public service and the private sector to work in a wide range of areas of law and policy. Working with top-notch lawyers in private practice, I learned a great deal about law and lawyering, and I had the opportunity to manage litigation concerning a broad spectrum of legal issues. But my heart has always been in public service, where I've spent the majority of my career. Our love of public service dates back even to my college years, when I studied political science at the University of Minnesota-Morris. And in college and law school, I took every chance I could get to gain government experience, including, of course, my internship with Chairman Grassley. My first experience with the Justice Department was way back during my 1L summer, when I worked as an honors intern at the FBI's National Security Division. Chairman Grassley and Senator Ernst have already described my professional biography, so I won't take up the committee's time repeating it. But I would just say that it was a tremendous privilege to serve in the Justice Department as Assistant AG for Legal Policy, working with components across the department to craft policy solutions to the challenges that they were facing. I am honored to be nominated to be Associate Attorney General. I am also humbled by the opportunity to take on such a serious responsibility. I have deep admiration and respect for the institution of the Department of Justice, for its critical work, for its tradition of independence, and for the dedicated public servants, lawyers, law enforcement officers, and many others who work there across administrations. If confirmed, I will strive to undertake my role with integrity, independence, and fidelity to constitutional principles and the rule of law. I look forward to entering back into public service, serving the Department of Justice, its client, the United States, and the public interest if I am confirmed. I also look forward to working with Mr. Rosenstein if we are confirmed. Thank you again for the opportunity to appear today, and I look forward to taking your questions.
I'll start questioning. For the benefit of both Republicans and Democrats on the committee, we will take you in the order that you were here when the gavel falls, and then for people that came in later on, it'll be according to how they arrived. And I would also ask that, including this chairman, not to take more than the 7 minutes. So if you still have 1 second left when you can start the last question you're going to ask, go ahead and ask the question at that point. I hope at that point our nominees will give a shorter answer, and I hope after your time is run out that you won't carry on dialogue that's kind of a debate going on between the nominees and you folks as well, because we got a lot of work to do today. I'm going to start with Mr. Rosenstein, but before I ask the 3 or 4 questions on this first point, the Attorney General has announced that he will recuse from any existing or future investigations of any matter relating in any way to the campaigns for President of the United States. That would include any investigation into campaigns for President and any communications with representatives of the Russian government. The Attorney General made clear that his announcement did not confirm the existence of any such investigation in accordance with department practice. In the event such an investigation were to take place, however, it would fall then to the position you have been nominated for as Deputy Attorney General in light of the recusal. So 4 questions that you can take as long to answer or short answers. I'll do one at a time. Have you ever met with representatives of the Russian government?
Not to my knowledge, Senator, at least not recently. And I have,
push the button.
Sorry, Senator. Over the course of my career, from time to time, I've spoken to groups of visiting lawyers and judges from foreign countries, and it's certainly possible there may have been Russian officials there, but I don't recall any such meetings, no.
Okay. When were you first in contact with the Attorney General about your nomination? Have you ever spoken to the Attorney General about the question of Russian contacts with presidential campaigns?
My first contact with Attorney General Sessions, I believe, was approximately November 28th, when I received a phone call from him. I don't believe I ever had any direct contact with Senator Sessions prior to that date. No, I've had no conversations with Attorney General Sessions about that matter.
About the Russian contacts?
Correct.
Okay. Is there any basis on which you would not be able to handle such these investigations, given that the Attorney General Sessions has announced his intention to recuse?
Senator, I'm not aware of any. I should tell you, of course, since I'm not involved in the matter, I don't know what, if any, investigation is currently ongoing within the department. So if I were confirmed, I would need to familiarize myself with the facts. I would need to consult with experts in the department. We have a complex set of rules and statutes that govern recusals. And so I'm not aware of any requirement for me to recuse at this time. But as a lawyer, Senator, I would have to know what it is I'm recusing from. And as a Department of Justice official, I'd have to rely on the advice I got from the career staff. We have folks who are trained to do just that.
I hope this next question is not an impossible one. How would you handle such an investigation? Have you ever discussed with the Attorney General the appointment of a special prosecutor to handle such an investigation?
Well, how I would handle an investigation, Senator, is the way I would handle any investigation. As far as I'm concerned, every investigation conducted by the Department of Justice is an independent investigation. We prosecute tens of thousands of people every year, and every one of those defendants deserves an independent prosecutor. And so I would be certain that we had independent investigators to conduct those investigations along with law enforcement agents who are trained to conduct their investigations in an appropriate way and comply with the statutes, the regulations, the Constitution, and the policies of our law enforcement agencies. And so that's the way I would do that, Senator, with regard to the special counsel in this or other cases. I know this is the issue du jour on Capitol Hill, but I anticipate that if I were the Deputy Attorney General, we'd have a lot of matters coming before the Department over time, and I would approach them all the same way. I would evaluate the facts and the law, consider the applicable regulations, consult with career professionals in the Department, and then exercise my best judgment if I were Acting Attorney General, or provide my best advice to the Attorney General if he were not recused about what I believe is the right course of action.
Yeah. I'd like to go to Ms. Brand now and ask you about your work at the Chamber of Commerce. When you worked there, your client, of course, was that chamber. In that capacity, you signed a number of briefs opposing the positions of government agencies. Of course, at the Department of Justice, your job will be to defend these agencies and their missions. Can you discuss how you will approach that from a different angle?
Sure, Senator Grassley, I would be happy to. As you say, as a lawyer, I have spent some of my career in private practice representing clients. I've, of course, spent more of my career in public service of one type or another. But just as when I was at a law firm, when I was at the Chamber of Commerce, I had a client, the Chamber of Commerce. And as a litigator there, my job was to file lawsuits and file amicus briefs on behalf of that client. If I'm confirmed to this position, of course, I'll have a very different role. I'll have a different client. My client will be the United States, and my role will be to serve the public interest and the interests of justice, representing that client as best I can. That's a role I'm very comfortable with. As I said, I've spent more of my career in public service than in private practice, and I would be honored to take that role back on if I'm confirmed.
Back to Mr. Rosenstein. You served as an associate independent counsel, and of course you've already referred to the decades of experience you've had in the department, so you're familiar with the role of independent counsels or special prosecutors in federal investigations. Appointment of a special counsel requires both that there's evidence of a crime or wrongdoing and that the department is unable to handle the matter fairly. Is that right, as you see it?
Generally, that's correct. I believe what you're referring to is the Department's regulation on special counsels as opposed to the independent counsel statute, which sunsetted in 1999. It would require, under the current regulation, a determination by the Attorney General or the Acting Attorney General. Number one, that a criminal investigation of a person or matter is warranted. Number two, that there is a conflict of interest for the department to conduct that investigation. And number three, that the public interest justifies the appointment of a special counsel.
Okay. Let me ask the question, but I think you just answered it. But if you want to say more, how would you decide whether a special prosecutor would be appropriate in a particular department investigation?
Well, whatever it is, Senator, and there are various formulations of this. As was mentioned in the introduction, I was specially designated by Attorney General Holder to conduct a sensitive investigation. I wasn't technically a special counsel under that regulation, but the bottom line is, Senator, that it's my job to make sure that all investigations are conducted independently, and whether it's a law or a statute or some other mechanism, I would ensure that every investigation is conducted independently.
My time's up. I have two more points on that question, but I'll do that in the second round. Senator Feinstein.
Thanks very much, Mr. Chairman. Mr. Rosenstein, earlier this year, the entire United States intelligence community made public its assessment that Vladimir Putin ordered a Russian influence campaign designed to interfere with the 2016 presidential election. The goal was to undermine public faith in the United States democratic process and to harm the campaign of Secretary Clinton in favor of President Trump. I am very concerned. I've been 6 years the chairman of the Intelligence Committee and on it for 16 years. So I've followed this closely, have had the Gang of 8 briefings, and feel very certain that the reports of the intelligence community are in fact correct. Have you read either the final classified or unclassified versions of the intelligence community's assessment regarding the Russian government's interference with the 2016 presidential campaign?
Senator, I'm certainly familiar with the issue from media accounts. I obviously have not read any classified report concerning it because it's not within my official responsibility as U.S. Attorney for Maryland. And I don't believe I've read the unclassified report. I believe I've read summaries in the media.
Well, I'm going to ask that you do that before your nomination comes up, if it does on the floor, if you will. Will you read those reports?
I think, Senator, if I were to become Deputy Attorney General, it would be essential for me to read those reports, probably the classified as well, if there is such a report. I don't think I'm authorized to do that.
Well, why don't we find out? You're number 2 now.
No.
Or will be number 2.
Yes. I think it's very important, Senator. I think that's a really valuable point, and I appreciate your raising it because the media reports actually have, I think, created some confusion about that. I am the U.S. Attorney for the District of Maryland. I have no role in managing the department. So,
right. No, I understand that.
Yes.
It was my fault. I misspoke, so thank you. Let me go on to the question of special counsel. And I mentioned in my opening remarks that when Valerie Plame's covert identity was revealed by someone in the Bush White House, Attorney General Ashcroft recused himself, and then Deputy Attorney General Comey promptly assigned Patrick Fitzgerald to be a special prosecutor with plenary authority to investigate and prosecute that case. Now, given the recusal by the Attorney General and the intense political interest in this matter and the strong potential that the investigation will in fact involve individuals associated with the White House, it would seem that this situation also rises to the level of extraordinary circumstances that warrant a special counsel under the regulations. Given all of this and the heightened level of distrust on all sides, do you support the appointment of an independent special counsel to look into these matters?
Senator, my understanding of this, and again, it's based solely on media accounts at this point, my understanding is that at least one of your colleagues called for a special counsel for something related to this matter while Attorney General Lynch was in office in early January, and she rejected the request. And based on the media accounts, I believe she said exactly what I said, that she had confidence in the career professionals of the department, but she had an additional piece of information. She presumably knows the facts, and I didn't, and she rejected that request. Currently, Senator, we have an acting Attorney General for this matter, Dana Bente. He was appointed U.S. Attorney by President Obama. And if there were a need for special counsel, he currently has full authority to appoint one. So I don't know at this point if Attorney General Lynch or Acting Deputy Attorney General Bente are right or wrong, but I certainly wouldn't be in position to overrule them without having access to the facts that are the basis for their decisions.
So I'm trying to figure out what your bottom line is. I interpret that as a no. Is that fair?
Well, I don't know, Senator. I think the answer is I'm simply not in position to answer the question because I don't know the information that they know, the folks who are in the position to make that decision. And when I am in that position, I don't presume that Attorney General Lynch and Acting Deputy Attorney General Bente are correct. I have a lot of respect for them, but if I determine that they're mistaken, then I would overrule them.
Thank you. I understand. Ms. Brand, if I may, while at the National Chamber Litigation Center, you led regulatory litigation directed against regulations to protect workers' rights and the environment. The President has now issued 2 executive orders aimed squarely at eliminating regulations. The first requires that 2 federal regulations be identified for elimination for every new regulation. The second requires regulatory task forces in each agency to make recommendations on repealing, replacing, and modifying existing regulations. As you may know, not all of the rules required by Dodd-Frank have been finalized or fully implemented, despite the fact that it's been nearly 7 years since it became law. By one measurement, over 100 rules still remain to be finalized, nearly a third of all the rules required by Dodd-Frank. It is concerning to me that these rules may not be proposed or finalized at all under the regulatory position of this administration, simply because there aren't hundreds of others found to offset. What is the legal justification for arbitrarily failing to issue a regulation called for under law simply because there aren't 2 regulations on the books to eliminate?
Thank you, Senator Feinstein. I am aware of those executive orders generally. I haven't studied them as I'm not yet in the department. With respect to the executive order ordering a review of regulations on the books, my recollection is that President Obama issued something quite similar during his term in office, and I haven't studied what the results of that study were. In terms of the other executive order, again, I haven't studied it, but I think that any regulatory action taken by any agency of the government has to comply with the requirements of the Administrative Procedure Act, which require reasoned decision-making. That statute remains in place, but as to the interplay between the APA and the executive order, those decisions would fall in the first instance to the regulatory agencies themselves, but I would have to study it further.
Thank you very much. Thanks, Mr. Chairman.
Okay. Senator Hatch.
Well, thank you, Mr. Chairman. Let me first say that I agree with you that there is no legitimate basis for asking the Attorney General to appear before this committee. It is unseemly at best to demand a hearing before the Attorney General has had a chance to address this matter further, as he has now done. Skipping that basic step of fairness makes it look like this is more about publicity and partisan posturing than anything else. At least it looks that way. Responding to written questions after his hearing, the Attorney General stated if a matter arose where he believed his impartiality might reasonably be questioned, he would, quote, consult with department ethics officials regarding the most appropriate way to proceed, unquote. Now that is exactly what he did. I wish I could say the same thing about his predecessor. She would not recuse herself from the investigation into Secretary Clinton's misuse of classified information. My Democratic friends had nothing to say about that. And like I said, this kind of double standard makes it at least look like partisan politics. I'd hoped we could start depoliticizing the Justice Department. Now let me turn to the nominees before us today. I want to congratulate both of you. You're excellent lawyers. I have great respect for each of you. Both Mr. Rosenstein and Ms. Brand are familiar to us, and I think each is well qualified in being asked to lead the Justice Department. Mr. Rosenstein, let me just ask you this question. I am the Senate sponsor of the Rapid DNA Act. It would allow the use of rapid DNA technology to help analyze crimes, exonerate the innocent, and prevent DNA extensive or analysis backlogs. Do you support the effort to allow DNA samples collected and analyzed with the use of rapid DNA technology to be included in the National DNA CODIS database?
Senator, I'm not familiar with the details of the legislation, but as you describe it, it certainly sounds like it would be a valuable tool for law enforcement. I think it's critically important that we arm law enforcement officers with modern technology so that they're best able to do their job of keeping us safe. And I know of many cases where DNA has been used effectively, both to catch dangerous criminals, rapists in particular. We hear cases like that all the time, and also to exonerate innocent persons, some of whom have been wrongly convicted. So I think DNA can be an extraordinarily valuable tool, and I believe we should arm our law enforcement officers with that sort of technology.
Great. I'm concerned about a lack of transparency in federally funded pretrial release programs. Individuals are often released without paying any bail on a promise to return to court and to meet the conditions of a pretrial program. If they fail to return or complete such a program, they become fugitives, and the taxpayers have to pay the price for billions in unpaid bills. Last Congress, I introduced the Citizens' Right to Know Act, which requires state and local governments that receive federal funding to report to the Attorney General on these pretrial release programs. What is your assessment of the pretrial release program?
Senator, I regret that I'm not familiar with those challenges. I know that in cases that I've supervised, we make every effort if we believe somebody poses a significant danger to the community to make sure they're detained prior to trial. And if somebody's eligible for pretrial release and they might be a candidate to be out in the community, then we would support that as well. But it's certainly important to make sure in either case that we have them available for court when the court date comes.
Thank you. Ms. Brand, You're here as part of the constitutionally prescribed appointment process. In that process, the President nominates but cannot appoint without the advice and consent of the Senate. We had a dispute a few years ago when the previous president attempted to appoint some officials without Senate consent. He tried to define for the Senate when we were in session and when we were in recess so that he could bypass the advice and consent requirement. In your capacity with the U.S. Chamber Litigation Center, you filed a brief arguing that the president exceeded his power under the Constitution. Am I right that the Supreme Court unanimously held that those appointments were unconstitutional?
Yes, Senator.
How important is it that the president abide by the limits of the Constitution, by the limits the Constitution sets?
Well, Senator Hatch, I think that it's important for every officer of the United States, whether in the executive branch, the Congress, or the judiciary, or in a regulatory agency, to stay within the bounds of the authority granted to them by the Constitution or laws of the United States. I think that divided governmental power, whether it's divided along federalism lines or whether it's divided horizontally with the separation of powers, is a critical protection of individual liberty and freedom.
Well, thank you. In 2008, you advocated against over-federalizing criminal justice. A growing number of experts and policymakers are also cautioning against over-criminalizing behavior. I've long been a proponent of a default mens rea, or criminal intent requirement in the federal criminal code. What are your thoughts about a default criminal intent requirement?
Well, Senator, I understand that legislation along those lines has been introduced. I'm not sure if it's pending now, and I would have to study the details of the legislation. I certainly do think that it's important to have an appropriate, or at least a clear mens rea for every criminal provision in the code.
Well, thank you. That's all I have today. I appreciate both of you. Appreciate your willing to serve. Appreciate the service both of you, each of you, has given to the federal government and to our fellow citizens in this country. Thank you so much.
Thank you.
Senator Leahy.
Thank you, Mr. Chairman. Ms. Brand, I do recall asking my staff to tell your child there was a place to be more interested in listening, even to your testimony, especially to the senators, the father and the grandfather. I understand that. Mr. Chairman, I know you said that you don't feel any need to invite the Attorney General back before the committee. I would note that his supplemental testimony last night did not even attempt to answer his misleading response to my question. And considering what the Russians appear to be doing to us, I do feel you should bring him back. Let me mention this. I watch you both being sworn in, and over my years here, I've watched hundreds and hundreds of people being sworn in. It's a very important oath, and Mr. Rosenstein, you said you memorized it. I'm sure you have. But many of the people who have testified so far this year as nominees, they've fallen short of this, and their misleading testimony only came to light after the press reported on it. Will you, I'll ask both of you, you can answer this yes or no. Will you commit to me that in the event you find a need to clarify any of your answers before this committee, you do so immediately and not wait until the press calls you on it? Mr. Rosenstein.
Thank you, Senator. I don't know if you've ever had the opportunity to be on my side of the table. We certainly make every effort to answer your questions fully.
No, but the answer is, if you were to go back over it afterward, and witnesses have, and they found something in which we left this out, and they've let us know, will you commit to do that before you have to be forced to do it because of something in the press?
Yes, I would.
Ms. Brand?
Yes.
Thank you. Now, Senator Feinstein, Mr. Rosenstein, asked you about the appointment of special counsel. I recall I was not in the Senate I was a young prosecutor when Elliot Richardson was asked the same question before this committee as the nominee for Attorney General in 1973. Watergate was unfolding. He promised the committee he would appoint an independent prosecutor if confirmed, saying that, I quote him, it was necessary to create the maximum possible degree of public confidence in the integrity of the process. And of course, he named Archibald Cox. He actually did that before the committee finished the hearing. Now, Russian hacking of one of our national committees, in this case, the Democratic National Committee, their efforts to influence our elections, their continuing efforts, not only in this country but other countries, to influence elections. It's just as serious as Watergate. Do you agree that accessing a computer or computer network without authorization, and then obtaining and disseminating another's documents and emails, is that illegal under federal law? Thank you. And, of course, according to the intelligence community, and I agree with Senator Feinstein, read the full report, both the public one but the classified one, and see about Russia's interference in our election. It was intended to undermine public faith. Do you agree that investigating what Russia has done is a matter of extraordinary importance?
Would you activate the mic?
I'm sorry. Senator, I don't know the details of what, if any, investigation is ongoing, but I can certainly assure you, if it's America against Russia or America against any other country, I think everyone in this room knows which side I'm on.
And well, I assume I do too, but would you also agree that American people, if there's such an investigation, they have to have confidence in the integrity of it?
I believe it's critical for the American people to have confidence in the integrity of our investigations, yes.
Suppose you're conducting an investigation and you find that it sweeps up communications between those under investigation and your own boss. Would you agree that raises challenges you might not have in a private investigation or in a typical?
Yes, it would, Senator.
I think Russian interference is one of the worst things I've seen in my years in the Senate. I mean, I've thought about this. I was in Vermont over the weekend, and I spent a lot of time going over it. I cannot remember anything in my years here that has troubled me more than have another country try to interfere. The National Security Advisor has resigned. The Attorney General has recused himself. The White House seems to be meddling in an investigation. Have you discussed with anyone from the administration or anyone connected with the president whether you would appoint a special counsel if you were confirmed?
I've had no communication with the White House at all about that issue, nor have I had communication with the Attorney General about that issue.
Okay. Are you willing to appoint a special counsel to examine Russian interference in our elections and other criminal activity?
I'm willing to appoint a special counsel, Senator, whenever I determine that it's appropriate based upon the policies and procedures of the Justice Department.
I'd ask you to go back and read what Elliot Richardson said.
I have, Senator.
Thank you. And the president has said that President Obama wiretapped his phones and the Trump Tower phones. Does any president have that authority to unilaterally wiretap somebody?
Senator, I have absolutely no information about that other than what I've read in the newspaper. And if I were the Deputy Attorney General, my office would have a critical role.
The question is, does the president have the unilateral authority to wiretap somebody's phones?
I don't know the details, Senator, and I'm reluctant as a lawyer to comment on that. In a criminal investigation, the answer would certainly be no.
Okay, the reason I ask, I would assume that if the president is not telling the truth about this, those who know the truth would say what the truth is. Thank you, Mr. Chairman.
Mr.
Mr. Rosenstein, Ms. Brand, congratulations on your nomination. I think you're both exactly the answer to the chaotic times we're living in. Professionals who are dedicated to the rule of law and not politics. I'm a little confused by some of my colleagues' statements today because they've called for an investigation. Actually, there's an investigation ongoing by the Senate Intelligence Committee and the House Intelligence Committee. I was out at CIA headquarters yesterday and observed 4 large binders full of classified information that's been made available to the committee to conduct that bipartisan investigation, one that Chairman Burr and Vice Chairman Warner have authorized, and I think that's the appropriate place for that investigation to take place, rather than some sort of select committee or some sort of media circus. I also am puzzled that, Mr. Rosenstein, you have appropriately been praised for your reputation as a professional prosecutor and somebody whose integrity is beyond reproach. But then my colleagues here ask you whether you'll abdicate those responsibilities without even knowing the evidence and appoint a special counsel. I think you've answered the questions appropriately, and I have confidence that you will apply the proper standards once you actually are confirmed. And then I hear some of my colleagues talking about the importance of getting the Justice Department on track, and yet then claiming they're going to block your nomination because of their concern about some other collateral matters. I just want to ask you, Mr. Rosenstein, you pointed this out earlier, but I think it bears repeating that you were appointed by the Obama administration, Attorney General Holder, to oversee a sensitive investigation to alleged leaks of classified information. Is that correct?
Yes, sir, that's correct.
And would you just briefly describe what that investigation entailed?
Well, the only thing I can describe for you, Senator, is the outcome of the investigation, because we don't discuss matters beyond what's in the public record.
That'd be fine.
The outcome of that investigation was that General James Cartwright pleaded guilty and admitted that he had made false statements in the course of an investigation into alleged unlawful disclosures, and he admitted that he had in fact made disclosures in violation of law.
Well, I would suggest to my friends that if you have the professionalism and integrity sufficient to conduct that sort of sensitive investigation, that I believe you're eminently qualified for this position to which the President has nominated you, and you will conduct yourself with the similar professionalism and integrity. Ms. Brand, as I said earlier, congratulations on your your appointment, and of course you've been before the committee several times in different capacities. But I wanted to ask you in particular about your role on the Privacy and Civil Liberties Oversight Board. As you know, Congress will have the responsibility of looking at the Foreign Intelligence Surveillance Act reauthorization for Section 702. We've got a number of other sensitive law enforcement tools and intelligence gathering tools which will be considered this year, and certainly when you're confirmed, you and Mr. Rosenstein will be playing a role in that. But could you just describe for the public generally what sort of oversight and protections that are part and parcel of these law enforcement and intelligence gathering tools? Because I think sometimes people lose that, and it's really important, it seems to me, for people to understand that there are oversight from all 3 branches of government, judicial, executive, and legislative, and the concern that we all have about privacy rights is protected by that sort of oversight.
Well, thank you, Senator Cornyn. I thought a lot about this, and I've written about this in my individual capacity and on the PCLOB. Which oversight mechanisms apply depends on which authority you're talking about, obviously, and these are very complex matters, and I hesitate to brush with broad strokes on something so complex, but As a general matter, take FISA, for example, there is oversight by all three branches of government. In a typical FISA application, there's extensive work done inside the executive branch, and there's judicial oversight, and then there's, of course, oversight by the committee that you sit on, the Senate Intelligence Committee, as well as the House Intelligence Committee. For certain programs, there is oversight by the Justice Department of the intelligence agencies. There is involvement by the Inspector Generals in some cases. There's involvement by the board I formerly sat on, the PCLOB. So depending on the circumstances, there could be quite a few levels of oversight for a particular government action.
Well,
I think that's appropriate.
I appreciate the complexity of talking about it from a 30,000-foot level and writ large, but I think it is important for the public to understand that there are a number of legal protections and oversight responsibilities that do protect privacy rights, while at the same time preserving essential law enforcement and intelligence gathering tools. I believe Director Comey has called Section 702 of the Foreign Intelligence Surveillance Act the crown jewels of the intelligence community. And it strikes me it would be a travesty, and indeed it would be dangerous, if for some reason Congress failed in its responsibility to reauthorize such an important law enforcement and intelligence gathering tool because of misguided concerns or unsupported concerns about lack of adequate oversight and protection for privacy rights. So that's going to be a very important part of the discussions. I think the House, if I'm not mistaken, Judiciary Committee is actually having a hearing on that today, or certainly this week. So we look forward to your contribution as we try to strike that right balance along with yours, Mr. Rosenstein. Thank you both for your service, and certainly look forward to supporting your nominations.
Thank you.
Thank you very much, Mr. Chairman, Mr. Rosenstein, and Ms. Brand. Thank you very much for coming by my office. I appreciate it. For the record, my friend from Texas raises a question about delay in filling these positions. Deputy Attorney General Jim Cole was held up by the Republicans in this committee 400 days before he was confirmed. Stuart Dellery, nominee to be Associate Attorney General under President Obama, was held up for almost a year. He never received a floor vote and ultimately withdrew his nomination. I trust you will be treated more professionally by this committee. Let me ask specific questions, if I can, about this issue of the Russian involvement. And Mr. Rosenstein, I respect the fact that you haven't read this report, but it's 15 pages long and it's on the internet, and it's not classified. And I want to read several paragraphs and really put in perspective why we're asking you these questions today. Because what we have learned from this intelligence report 2 months ago is historic. It is a cyber attack on the United States of America like none we've ever seen before. I quote from our intelligence agencies: Russian efforts to influence the 2016 U.S. presidential election represent the most recent expression of Moscow's long-standing desire to undermine the U.S.-led liberal democratic order. But these activities demonstrated a significant escalation in directness, level of activity, scope of effort compared to previous operations. The intelligence agencies say, we assess Russian President Vladimir Putin ordered an influence campaign in 2016 aimed at the U.S. presidential election. Russian goals were to undermine public faith in the U.S. democratic process, denigrate Secretary Clinton, harm her electability and potential presidency. We further assess Putin and the Russian government developed a clear preference for President-elect Trump. This was not put up by the Democratic National Committee. This was published by our intelligence agencies. And it's the reason that many of us believe this is not like an ordinary investigation by the Department of Justice. This is historic. It's always critical when it comes to filling these appointments. But this is an historic constitutional moment in our history. So I'd like to ask you, Mr. Rosenstein, will you commit that if you're confirmed, you will not impede or shut down any FBI or Justice Department investigation into Russian efforts to influence the 2016 U.S. presidential election?
Senator, on the issue of foreign interference in American elections, I can assure you that you and I are on the same side. I will certainly support any properly predicated investigation related to interference by the Russians or by anybody else in American elections.
I might say for the record that Attorney General Sessions was asked that same question at his confirmation hearing, and he would not make that same commitment. Second question, will you commit to promptly inform the American people if the Department of Justice closes, terminates, or declines to further pursue an investigation into Russian interference in the 2016 U.S. presidential election?
I'm sorry, Senator, what exactly is the...
Inform the American people if the Department of Justice closes, terminates, or declines to further pursue an investigation into Russian interference in the 2016 U.S. presidential election.
Senator, I've been a prosecutor, as you know, for 27 years, and our primary responsibility as prosecutors is to collect the evidence and determine whether or not we can prove a case in court. Often there are other concerns that arise in investigations, and in this particular one, Senator, I think I would need to consult with the director of the FBI and with the intelligence community before I make any commitment about what would be the outcome of such an investigation.
I'm asking you if the outcome is closing or terminating or declining to further pursue the investigation. Would you report that to the American people?
Senator, I don't want to make any commitment about what I would do at the conclusion of an investigation without knowing the details of the investigation. Talking with the director of the FBI, I can assure you that if it's appropriate to release it to the American public, I would.
Do you pledge to continue to pursue any ongoing investigation by the Justice Department into Russian interference in the 2016 election or any other attempts Russia may have made to undermine the United States, our political system, or our position in the world?
If there is an ongoing investigation in the Justice Department into interference with our elections by Russia or anybody else, and it's properly predicated and there's a basis for a federal investigation, then absolutely I would support it.
This is another question that Senator Sessions refused to answer in his earlier hearing. I'd like to ask you about the scope of the Sessions recusal. I'm not sure where we stand today based on the letter which this committee received from the Attorney General. Have you had an opportunity to read the wording in his recusal and the letter that he sent this committee?
I'm familiar with it, Senator, from media accounts. I was pretty busy with your colleagues yesterday. I know I didn't read the letter yesterday, but I'm generally familiar with it.
What he said in his recusal Thursday, quote, I have now decided to recuse myself from any existing or future investigations of any matter relating in any way to the campaigns of the President of the United States. This, I might say, is a partial recusal when it comes to the investigations into Russian influence on President Trump and his circle of advisors and associates. This recusal does not extend to post-election Russian contacts with the Trump transition team and the Trump administration, like the Russian ambassador's meetings with Jared Kushner and Michael Flynn, on its face. But yet the letter which the committee sent says in its final paragraph, and I read, the March 3rd, 2017 letter, which many of us sent to Attorney General Sessions, also asked why I had not recused myself from, quote, Russian contacts with the Trump transition team and administration. The Attorney General says, I understand the scope of the recusal as described in the department's press release would include any such matters. So do you believe that this recusal now would affect any Russian contacts with the Trump transition team or administration?
Senator, I'm familiar with the department's recusal policies and regulations, and they're actually more complicated than you might think because we're governed by the general government-wide conflict of interest provisions in Title V. We're governed by the Code of Federal Regulations, Title V government-wide. We're also governed by a particular statute in Title 28 and by regulations that apply to the Department of Justice under Title 28 of the Code of Federal Regulations. In addition to that, as lawyers, we're governed by bar rules. So there are a lot of policies that apply, and that's why it's important for us when these issues do arise to consult with career professionals. And I think it's important also, Senator, to understand that what we tell our people is that when you recuse, there's no presumption you've done anything wrong. You recuse because the issue justifies your recusal. So I don't know the details. If I were confirmed, I would certainly make sure that if the Attorney General were recused, that I wouldn't discuss the matter with him, and I have not discussed the matter with him.
Thank you, but that's not my question. What I'm asking you to do, and I want to give you the time to do it properly because this is an important matter, and I know you're an excellent attorney and want to get this done right. I want to give you the official recusal by Attorney General Sessions of last week and his letter which he sent to this committee and ask you for clarity as to the scope of this recusal. I think that the Attorney General left a wide gap in there about contacts between the Russians and the transition team and any members of this administration. And I want to know how you read it in light of these two, and I want to give you the time to do it properly and professionally.
Senator, I appreciate it, but I just don't know how I would have a basis for evaluating that without access to the information. I presume that the Attorney General consulted with career professionals in the department who knew the facts. And if I become the Deputy Attorney General, and I believe that that's not a sufficient recusal, I'll certainly consult with them. But if I were to read it today, Senator, I would only know what you knew. I wouldn't know what was the nature of the investigation. I wouldn't know what's under investigation that you may or may not need to recuse from. So I just wouldn't be in position to comment on whether it's adequate. But I do know that I know the people in the department who make these decisions. These are nonpartisan career folks, and I believe they would have made a good faith effort to appropriately.
Mr. Rosenstein, I'm not questioning the process. I'm just asking for clarity as to the recusal of the Attorney General in his own words, not for the entire process that led up to his conclusion. I'm asking you how you read his own words. Mr. Chairman, I yield.
Senator Lee.
Thank you, Mr. Chairman. Thanks to both of you for being here. One of the reasons why our republic is strong is because we've got strong public servants who are willing to offer their service, even in difficult jobs. Ms. Brandt, I'd like to start with you. In 2008, you wrote a memorandum that was later published by the Heritage Foundation, and you approached the topic of the over-federalization of criminal law. One of the things that you wrote in there was that quote, trimming back the federal criminal code by eliminating offenses that should be investigated and prosecuted by the states has long been a goal of policy experts and good government advocates. This exercise in federalism is worthwhile both for its constitutional merits and for its effect on government accountability, close quote. This coupled with the fact that in one answer a few minutes ago you managed to put in a plug for both restoring federalism and separation of powers won me over because I happen to believe that our drift away from federalism and separation of powers has caused problems that are by their very nature neither liberal nor conservative, neither Republican nor Democratic. They're law and order kinds of concerns. They are structural concerns, they're constitutional concerns, and ultimately they get to this point of accountability. Would you agree with me if I took what you wrote in there and said that that could be applied to basically every instance, not just in the criminal law, but given that the position that you'll be involved in will be dealing primarily with civil issues, federalism and separation of powers are important, and that every time we drift from them, whether it's in the context of criminal law or of a civil matter, that we're limiting accountability of government.
Yes, I do, Senator. I think that the Department of Justice should be governed by the principles enshrined in the Constitution. I certainly would consider myself governed by them. And the Constitution, I think, brilliantly divided government for the protection of individual liberty. So, yes, I absolutely agree with you.
Oh, thank you. Given that you'll be overseeing the civil litigating components of the department, I also wanted to ask you, when is it appropriate for the department to decide not to defend a particular federal law? What's the standard that you think ought to be applied there?
Well, if you're talking about defending an act of Congress from a constitutional challenge, for example, I think the department's obligation is to defend an act of Congress whenever there is an available, reasonable legal argument to be made.
And that itself has its roots in the separation of powers, does it not?
Yes.
Given that we make the law, and if the executive branch isn't doing its job, then nobody's accountable as they should be.
Yes.
Mr. Rosenstein, one hot button topic that has come up again and again in the last few years involves prosecutorial discretion. This is a topic that I discussed with Attorney General Lynch and also a topic that I discussed with Attorney General Sessions when each of them came through this committee. Do you think that the government should exercise prosecutorial discretion on a case-by-case basis, or is this something that the government can decide to apply as a more general matter based on policy considerations?
That's a difficult question, Senator. I think the answer is a little bit of both. We have general guidelines. The Department of Justice is currently governed by what are known as the Attorney General's prosecution guidelines. They actually were developed by Attorney General Civiletti during his tenure in the Carter administration. They're in the U.S. Attorney's Manual, Title IX, Section 27, and they establish sort of the general criteria in all cases that prosecutors ought to look to in determining whether or not to bring a particular case. And one of the factors is federal law enforcement priorities. So at a high level, the determination needs to be made, what are our priorities? And then at a lower level, given that a case falls within a priority, what are the factors that determine whether or not to prosecute that individual case? So I think the complete answer to your question is it's a combination of both policy judgments about where to focus our resources, and then ultimately in every case it needs to be an individualized determination about whether the facts in that case justify a prosecution.
Thank you. With respect to minimum mandatory sentences, we talked a little bit in my office about the fact that in your office, in the U.S. Attorney's Office that you lead, you've been fairly conservative or cautious about how you charge crimes involving minimum mandatory sentences. Unfortunately, we didn't have enough time to go into a lot of detail there. Can you talk to me a little bit about your office's practices with regard to minimum mandatories and how those might reflect the approach you'll take in the Department of Justice if confirmed?
Yes, Senator. We comply with the Department's policies concerning when to use mandatory minimum sentences. And there are many cases that we deal with that involve extraordinarily dangerous people who deserve to be sent to prison for lengthy periods of time. And in those cases, we apply the mandatory penalties that are available to us. In many cases, using a mandatory minimum penalty, prosecuting or charging a defendant with a mandatory minimum penalty results in cooperation from that defendant. And if we're able to do that, that's one of the ways we're actually able to help. One of the areas where federal prosecutors are particularly able to help our local colleagues in Baltimore and probably in other cities is that we're able to break this no snitching code that is such a problem with violent gangs in many of our cities. We're able to break that by catching a defendant who has committed a serious crime, holding him accountable under the penalties established by this Congress, and offer him the opportunity to truthfully provide information about other crimes that he knows. And using that power, Senator, we're able to break the backs of some of these violent gangs in our communities. So I think it's critically important that we have those penalties available to us in appropriate cases. But as you say, we also need to take into consideration whether in a particular case it would be excessive. And there are some cases where we have discretion under department policies. And in those cases, we faithfully apply the policies and use those mandatory penalties only when they're justified.
Thank you. Briefly, in the time I've got left, I want to talk to you a little bit about civil asset forfeiture. Equitable sharing is a program that the department suspended in December of 2015, a lot of budget cuts. That program was resuscitated a few months later in 2016. Would you consider making changes to or possibly even ending equitable sharing, at least where equitable sharing in the civil asset forfeiture context is used to circumvent state and local laws restricting civil asset forfeiture by state and local law enforcement officials?
I would certainly, Senator, consider changing the policies. I'd be reluctant to commit to completely terminating the policy. It's a law enforcement tool that's available to us, and I think in appropriate cases we need to use the tools that are available to us.
Thank you. I see my time's expired. Thank you, Mr. Chairman.
Mr. Rosenstein, good morning. Many attorneys general have defended the Department of Justice from political interference by restricting contacts between DOJ and the White House to a select few officials. What will be the department's policy in this administration?
Senator, I believe the department's policy is and will be that communications with the White House concerning cases, that's the most sensitive matter, need to be cleared through the Office of the Deputy Attorney General. That's been the policy. I believe it was the policy when I worked for Phil Hyman as Deputy Attorney General in 1993. And I think it's really important, Senator, that everybody understands that there needs to be a single point of contact, because if you have...
and at the White House?
Pardon me?
At the White House. Could anybody at the White House call you about cases?
Well, anybody could call, Senator. They're not going to get an answer. My understanding is that...
Well, in fact, isn't the rule that they shouldn't even call?
I believe the rule, Senator, is that the communication should be between the White House counsel or deputy counsel and the Deputy Attorney General.
Precisely. And you're prepared to enforce this as Deputy Attorney General?
I've enforced that, Senator, as U.S. Attorney. Occasionally we get calls from people who shouldn't be calling. Usually it's a congressional staffer who doesn't know the rules rather than somebody at the White House. But I think it's important we circulate that. And people do it innocently. I don't mean to accuse anybody. People don't know the rules if they're not in the department. We need to know the rules. And we need to enforce.
And the White House needs to know the rules.
Yes, sir.
Why is it important that prosecutors not reveal derogatory investigative information about individuals who have not been charged with an offense?
I think that speaks for itself, Senator. And
I would like to hear you say it.
My guidance for this and many other issues is Robert Jackson, who was the Attorney General of the United States, gave a speech that is still stands as, I think, the best articulation of the principles of the federal prosecutor on April 1st of 1940, and he explained that that is the most significant power of the federal prosecutor, and it's subject to abuse, that we need to refrain from disparaging people unless it's necessary and justified in a case. So if we charge somebody with a crime and it's appropriate to introduce evidence against them in court, we do it. If we don't charge them with a crime, we have a responsibility not to disparage their character.
And even where an individual is charged, you don't divulge derogatory investigative information beyond what's charged in the information or the indictment, correct?
Well, we don't do it gratuitously, Senator. It might be appropriate in the course of a judicial proceeding, a detention hearing or
correct.
Trial, for example.
Yeah. In 2010, the Department of Justice propounded a memo suggesting that the Office of Legal Counsel attorneys do not owe a duty of candor to their clients that is equivalent to the duty of candor that workaday attorneys are held to in court proceedings. I understand that the Department of Justice has since corrected that and that OLC attorneys are treated as being held to a duty of candor equivalent to that of workaday attorneys in court. What duty of candor will you hold OLC attorneys to in the performance of their functions?
Now, Senator, I'm not familiar with that issue. The duty of candor is not just an internal department policy, it's an ethical rule governing lawyers, so I would certainly enforce that rule.
We'll follow up then with a question for the record for a more fulsome response. Did the department's civil case against the tobacco industry years ago have merit, and was it an appropriate use of the department's authority?
Senator, I do not know the answer to that question. I apologize. I'm just not familiar with it. It may or may not be. I'm not familiar with the details. I certainly recall reading about it, but if I get the job, Senator, there are a lot of areas I'm an expert in. There's some areas I'm not, and I regret I'm just not familiar with the details of that, and I couldn't comment on whether it was or wasn't an appropriate exercise of authority.
Is the holding in that case correct that corporations do not have a First Amendment right to fraudulent speech?
I believe that's correct as a matter of law, yes.
Matter of law, isn't it? Do you know if the Department of Justice is looking into connections between Russia and the Trump campaign?
I've answered that before, and I do not. I know what I read in the newspaper, and many of you, Senator Cornyn mentioned, may know more than I do about that, so I do not know the answer to that.
In the event that there were such an investigation, would the content of communications between Russian officials and Trump surrogates be relevant to such an investigation?
It may be, Senator. I don't know the details of the investigation, so I'm not in a position to comment on what may or may not be relevant.
As a matter of logic, it would likely be relevant, would it not?
If that's what we were investigating, it would certainly be relevant.
It would certainly be relevant. Would contacts between Trump surrogates and the Trump campaign regarding surrogate communications with Russia also be relevant to such an investigation?
Senator, when we conduct criminal investigations, we conduct thorough criminal investigations, so I can assure you that if our investigators and prosecutors determined that that sort of information was relevant to an investigation, we would get that information.
And you understand that those answers make Attorney General Sessions a likely witness in any such investigation?
I don't, Senator, but I do understand that the Attorney General has recused, and I'm not going to discuss it with him.
With respect to discussing ongoing investigations, do you agree that if all the shop windows are broken on Main Street, it is appropriate for the police chief to announce that he intends to get to the bottom of it and to assure the public that law enforcement will respond?
Circumstantial evidence, Senator, unless there were a hurricane, that would be evidence that some crime might have occurred, yes.
And when there is public awareness that a crime has occurred, it's not only appropriate, it's really incumbent upon law enforcement to assure the public that it will go about its duties and take what steps are necessary to enforce the law.
Yes.
And people do that all the time.
Yes, we do.
If police chiefs do it, you've done it as U.S. attorney, DAs do it, people do that all the time. Is not the public report on Russian election manipulation the equivalent of broken windows on Main Street? Doesn't the American public now understand that there has been a very significant piece of damage done to our election process by a foreign government as a result of that report?
Senator, I believe that you and I are on the same side. If the Russians interfere with American elections, then I'm on the American side.
And it's appropriate for you, when you have that information, to assure the American public that it will be appropriately investigated and that there is, in fact, investigation taking place.
You know, the complication here, Senator, I don't mean to be difficult in any way. I'm trying to be as helpful as I can, but there has been repeated reference to intelligence equities here, and I know nothing about that. So one of the challenges that we face with foreign hacking, and this is an issue I know something about outside of the context of this case, we need to figure out who's responsible for it. Is it a foreign government? Is it an intelligence issue? Is it a law enforcement issue? And that's a challenge.
But the question whether the Department of Justice is conducting an investigation into this is one that is appropriate for the Department of Justice to answer. Correct?
Yes, absolutely.
There we go. My time's expired. Thank you, Chairman. I appreciate it.
I want to thank Senator Kennedy for letting me to cut in line here. Did you read or hear about President Trump's tweets regarding his assertion that President Obama was involved in monitoring his campaign or the Trump Tower?
I certainly did read about the tweets that were reported over the weekend, yes, sir.
What was your reaction?
I don't think it's appropriate for me to share my reaction, Senator. That has no bearing on my work. If the President gives me an instruction in the context of an order to carry out any sort of investigation, that's my job. If the President is exercising his First Amendment rights, that's not my issue.
He called on Congress to investigate. Do you think that's a reasonable thing for him to do?
That's a political issue, Senator. It's not an issue.
Well, let me just say yes, and we will. The bottom line here is if there was a warrant issued regarding Trump campaign activities and Russian contacts, would you in your new job, if you're confirmed, know about that warrant request and whether or not it was issued?
I would hope, at least prospectively, that I would. I don't know to what extent, if something like that were done in the past, it would be appropriate for me to review it.
Are you telling me as a Deputy Attorney General you wouldn't know if the Department of Justice applied for a warrant?
I hope that I would.
I hope you would too. Now there's a Title III warrant, I think that's the right title, a criminal warrant, and there's the FISA court. Are you familiar with the FISA court?
Yes, I am.
Would you be able to tell us as Deputy Attorney General, if you confirmed, whether or not a request was made to the FISA court to monitor Trump campaign activity and the Russians?
Would I be able to? I would presume that I would be able to. Whether it would be appropriate for me to do so would be another question.
Okay, why would it not be appropriate for you?
I just don't know, Senator. You know, I have, in my capacity as U.S. Attorney, I've dealt with FISA issues when they become relevant to criminal cases, but I'm not an expert on the statute.
Okay.
And I know they're intelligence community equities, and I need to consult with them before I made any decision.
Okay. So there's three ways this could have been done. You could have gotten a warrant through the normal criminal process. That would have been lawful if a judge granted it, right?
Hypothetically, we do that all the time. Yes.
Okay. Number two, you could have a FISA court, which is a little bit different, but it's still the court overseeing someone's request, right?
Yes, that's correct.
The third would be if the President Obama on his own decided to wiretap Trump Tower or the campaign. Do you know of any basis that he would have the ability to do that without a FISA warrant or without a warrant from a federal judge in a criminal investigation?
No, I do not.
Okay. As a matter of fact, he could not. No president can just unilaterally say, go wiretap that American citizen. Right?
Senator,
without court approval.
You know, I'm a lawyer, Senator, so...
Well, no, you're not going to just be a lawyer. You're going to be the Deputy Attorney General.
Well, here's the thing, and I don't... I'm a lawyer, and if somebody tells me nobody can do that, my answer is...
Well, in writing, later on, tell me how the President of the United States could unilaterally wiretap an American citizen, an American company, an American campaign for president without some court approval.
So my answer to that, Senator, is I would hope, and I agree with you, that that would not happen.
Yeah. Okay. Are you familiar with the executive order regarding the DACA kids that President Obama issued?
Only by virtue of having read about it in the newspaper.
Okay. Do you know if it's constitutional or not?
I do not.
Okay. The executive order was to give legal status to, I think, 800,000 kids who were called DACA kids. They came here as small children, and President Obama gave them through an executive action legal status. Can you get back to me as to whether or not you think that falls within the president's prosecutorial discretion?
I don't believe it would be appropriate for me, Senator, to comment on an issue like that that might well be litigated, and my position I would have to consult with the appropriate experts in the department and reach a legal conclusion about what judgment to take. I would not offer an opinion, prejudge a case like that prior to or apart from the context of having to litigate it in my capacity as Deputy Attorney General.
Okay. Now, if there is an investigation regarding the Trump campaign and Russian contacts, would be two stages. One, the gathering of the evidence and a decision whether or not to proceed forward in a prosecution fashion. Is that correct?
This is a hypothetical, Senator.
Yes.
We're talking about some tweets. I don't know about any investigation.
Well, just any investigation.
Yes.
So you'd want an independent person advising the investigators while they're gathering the facts, not just making the decision of disposition. Is that correct?
You would want independent advice, yes.
Okay, so can you assure this committee, if there is such an investigation, that you would make sure that the investigators are advised by a professional lawyer at the Department of Justice who's independent, even during the gathering of the facts?
I hope I've made that very clear, Senator, that I would view it as my responsibility as deputy to make sure every case was investigated independently.
Now, is it true that the current acting Deputy Attorney General could appoint a special counsel if they believe that was appropriate?
I believe that's correct.
Okay, and that person was appointed by President Obama?
That's Dana Bente, the U.S. Attorney from Eastern Virginia. That's correct.
Okay, if you take over and you get confirmed, then would it be your job, since the Attorney General recused himself?
In any matter in which the Attorney General was recused, the acting Attorney General would have that authority.
Generally speaking, when the subject of the investigation has a political bent to it, do you believe that you could do that job even though you've been appointed by this president?
Absolutely, Senator, and you have to recognize that we have a lot of policies regarding recusals and conflicts, but we also have a proud tradition. In fact, my office in the District of Maryland, in 1972, I believe it was, the U.S. Attorney George Bell, a Republican U.S. Attorney appointed by a Republican president, prosecuted the Republican Vice President of the United States. So I believe that I certainly do.
So do you believe all of your time before taking this job has prepared you for that moment, if that moment ever comes?
I certainly hope so, Senator.
Okay. Sentencing reform. Are you familiar with the efforts by this committee and others to pass sentencing reform?
I'm generally familiar with the issue, yes, Senator.
Okay. Do you have a general opinion as to whether or not we need sentencing reform at the federal level?
I think, Senator, that it's always appropriate for the Congress to evaluate the tools that are available to federal prosecutors and to assure yourselves, number one, they're being used appropriately, and number two, whether or not there are additional tools that they need or tools that you provided them that perhaps you should take away. So I think that it's appropriate for that to be an ongoing process.
Thank you.
Thank you very much, Mr. Chairman. I'll start with you, Ms. Brand. You have a good choice of colleges in Morris, Minnesota, so thank you for that. I wanted to start with something pretty important to me because my dad was a journalist for many, many years, and that's freedom of the press. I raised this issue with the Attorney General, and he said in his confirmation hearing that he was still reviewing the regulations, yet in 2015, the Attorney General the then Attorney General revised the department's rules for when federal prosecutors can subpoena journalists or their records, and he committed to releasing an annual report on subpoenas issued and charges against journalists. The previous two Attorney Generals also committed not to put reporters in jail for doing their jobs. First of all, what are your views on the standards that Attorney General Holder put forward and were upheld during Loretta Lynch's tenure?
Thank you, Senator Klobuchar. That's a very important issue. Obviously, the freedom of the press is one of the freedoms enshrined in the First Amendment to the Constitution. I'm aware of those guidelines, but I must confess, since I have not been in the department in about 10 years, I have not studied them. I understand that they heightened the standards which were already I think, relatively strict in terms of the circumstances in which the department could subpoena a journalist. They require high-level approval. They would,
So would you uphold those standards? What's your answer on it?
it would not actually be within my authority to do that, Senator. That would be under the purview of the Deputy AG. I hate to throw him under the bus, but I can't commit to you because it's not going to be my decision.
Okay, then we'll go to you, Mr. Rosenstein.
You know, I apologize, Senator. I thought Rachel was going to handle that question. Would you restate it, please?
That's what I thought. What's your answer? Okay, I get it. Okay, the question is about...
Yes or no?
That's all right. A yes or no answer on the standards that Attorney General Holder had put forth to protect the freedom of the press. He revised the department's rules for when federal prosecutors can subpoena journalists for their records.
Yes, Senator, I am familiar with those rules, and they've been modified over time. And I think it's important for the department always to be willing to revisit our internal policies to make sure we get it exactly right, because sometimes, we find out that we didn't have it exactly right the last time. So as a general proposition, I think those rules, and if you wanted a yes or no answer, and I apologize, but it's a balancing. The rules reflect a balancing, and I think it's important for us to heavily balance First Amendment concerns and freedom of the press.
So are you going to review the rules, or where are you on the rules?
I don't have any plan to review the rules, but I wouldn't rule it out if somebody thought it was appropriate to take a look at them.
But right now you would leave the rules in place?
I'm not aware of any plan to revisit them.
Okay. I'm going to follow up on some of Senator Graham's questions about what happened over the weekend, where news reports stating that FBI Director Comey called on the Justice Department to publicly reject the president's recent assertion that President Obama ordered the wiretapping of the phones in the Trump Tower during last fall's campaign. So my question is this, it's not specifically on that. In a situation where the President of the United States makes a factual statement about the status of an investigation and that statement is later determined not to be correct, this is on an investigation, what is the responsibility of the Justice Department to set the record straight?
Senator, I think that I cannot answer that in a hypothetical way. It wasn't my understanding that it was a comment on a Justice Department investigation. Maybe it was. I was somewhat distracted this weekend with other issues. I'm familiar with the tweets, but I just can't answer that. I would certainly, what I would do, I can commit to you what I would do in any situation like that. So I'd talk to the FBI Director, Jim Comey, and I'd certainly consider his views, and I'd make an independent determination about what to do under those circumstances.
But it would be your call to make that decision and not the director of the FBI's call.
Since I don't know exactly what decision was made, what I've read in the newspaper purports to be leaks of what may or may not have occurred, so I don't know exactly what the protocol was.
Okay.
But I would anticipate that obviously the FBI reports the Deputy Attorney General, and Mr. Comey was the Deputy Attorney General, so I'm sure he appreciates that chain of command, so it would be my responsibility, yes.
Okay. Are you aware, again, of any time FBI agents or the Department of Justice wiretapped a U.S. citizen without a proper warrant, since you've been a U.S. attorney?
Not on my watch, no, Senator.
Okay. And are you aware of an instance in which FBI agents or the Department of Justice personnel sought a warrant without a good faith belief that probable cause existed?
Not on my watch, no.
Okay. Now I want to turn to Russia. In your statements, and you and Senator Durbin went back and forth, at some point today, I think maybe with Graham, you said, if Russia interfered. And I know you have not read that 17-page report that we're all referring, the public report that the 17 agencies put out. It's short, and I just ask you to review it because basically you are putting yourselves in the shoes of the Attorney General when it comes to this, whatever investigation may come out of this. That's why all the media was there. I bet you we've never had that many reporters here for a Deputy Attorney General. I don't think we've ever had this much interest in a hearing like this, and it is because you will essentially be putting yourself in his shoes. And so I'm just asking that you read that report so I can ask you the same question I asked now Attorney General Sessions, and that's whether or not he believed there was any reason to doubt that evidence. He said there was no reason to doubt it.
I suppose I should clarify. As a lawyer, maybe sometimes I'm too careful with my words. I have no reason to doubt the conclusion of the intelligence community.
Okay.
As a lawyer, as a prosecutor, the issue for me is what can I prove in court, which may be a different issue from what I believe, but I certainly have no reason to doubt the intelligence community's conclusions.
Okay. And I so appreciated your opening statement where you said you look at things, as a prosecutor says, and that is what can I do, what should I do, and then the last thing is how do we explain things? Because I think way too much of this administration so far has been, whether it's the refugee order, whatever it is just about explaining things. You don't have to comment about this. Instead of first asking what is the right thing to do and what can I legally do. And so that's where I want to get to. If, in fact, you in this matter or in any other matter end up appointing a special counsel, which could happen, but in this matter, you would be the one to make the decision. 28 CFR section 600.4 says that the scope of any special counsel's investigation will likely be determined by the acting attorney general for the purposes of the investigation. How would you define the scope of any investigation? It also says that you could overrule a special counsel's decision. When would you be willing to overrule a special counsel's authority? So the question is, under the rules, how would you define the scope, and would, in fact, when would you be willing to overrule?
Thank you, Senator. In court, we would ask the chairman for opportunity to respond. I know our time's expired. Okay. A complete answer to your question would take a lot of time. I don't want to take away from your colleagues' time or prolong the hearing.
Oh, they don't care. That's fine.
Yeah, we're fine.
I think there was an independent counsel statute. Under the independent counsel statute, we appointed prosecutors who were not accountable to the Attorney General of the United States. That expired. Under current law, every special counsel we appoint is accountable to the Attorney General.
That's correct. And in this case to you, if it was on the part that the Attorney General accused himself.
Right. And this was, of course, true in the Watergate era. Archibald Cox was fired by the acting Attorney General. But the authority that I would give to a special counsel would be whatever authority is appropriate to make sure that he or she had the full range of authority to conduct the appropriate investigation that's required and justified by the facts and the law, just like we do in all other cases within the department.
Senator Kennedy.
Thank you, Mr. Chairman. Good afternoon. Mr. Rosenstein, can we agree that there's a difference between interfering with an election and actually changing the outcome of an election?
That's not an issue within my jurisdiction, Senator. If somebody interferes, it would be potentially a crime, whether it has an impact on the outcome or not. My answer is yes, there is certainly a difference.
Well, let's suppose that you're running for office and a super PAC runs ads criticizing you. The super PAC would be interfering legally in your election, but those ads may not impact the outcome of your election. Do you see the distinction I'm trying to make?
I do, and I apologize because I assumed that by interfere you meant unlawfully interfered. If somebody interferes lawfully, that would not be a law enforcement issue. They have a First Amendment right to do that.
Well, you can lawfully and unlawfully interfere.
If that's your definition of interfere, yes, sir.
Do you believe that Russia interfered with our elections in November?
Well, as I indicated in response to Senator Klobuchar, my understanding is that's the conclusion of the intelligence community. That's my only basis of knowledge, Senator, and so I have no reason to doubt that.
Can we agree that Russia has interfered in past elections in America?
I do not know the answer to that, Senator.
Okay. Have you ever heard of a group called Service A, which is the active measures branch of the first chief directorate of the KGB?
I do not recall ever hearing of that group.
Well, that's who did it. Are you aware that in 1968, Service A attempted to head off the election of Richard Nixon? The Kremlin offered to subsidize the campaign of his rivals. Are you aware of that?
Respecting one of your colleagues' earlier comments, I think I may have heard of Service A in newspaper stories about this, but that would be my only basis of knowledge.
Okay. Are you aware that in November of 1984, Service A tried to stop Ronald Reagan from being reelected?
I have no personal knowledge of that, no, Senator.
Okay. Are you aware that Service A planted stories in the United States that former President Kennedy was actually killed in a secret CIA plot?
I'm certainly aware that of some of the issues from the Cold War era, Senator, but I don't recall those specific details.
Okay. All right. Well, can we agree that that Russia's interference, if any, in the election in November was not the first time it's tried to do that.
I simply don't have any personal knowledge of that, Senator. I accept your representation. If that's what the intelligence community concluded, I have no reason to doubt that, and I would be offended by it.
Okay. Well, let's get down to it. You're going to be in charge of this investigation. I want you to look me in the eye and tell me that you'll do it right, that you'll take it to its conclusion, and you'll report to the American people your results.
So, Senator, I would do every investigation within my authority right, and I believe that the 115,000 employees of the Department of Justice will support me in that, and we'll take it to the appropriate conclusion. The reporting aspect, Senator, I just don't know what that entails. When you're talking about national security information, there are a lot of agencies that have equities in that, and not just the Department of Justice. And I don't have experience with that. That's one of the areas where I would have to rely heavily on career officials. So I can assure you that as you know, I highly value our responsibility to inform the American people to the extent we can. So that's sort of my default position. If we have a lawful basis and it's appropriate for us to provide public information, I think it reassures the public when they know what we've done and why we've done it. So that would certainly be my preference.
Well, let me rephrase the question. Will you be willing to do what I just asked within the parameters of national security?
Within the parameters of national security and the law, yes, sir.
Okay. I happen to believe that a U.S. attorney is the most powerful position in American government. I guess maybe being president is more powerful, but...
I hope so.
Well, it's an enormous amount of power. I mean, a U.S. attorney's job is to protect the American people. But at the same time, a U.S. attorney can ruin somebody's life. Are you comfortable with the checks and balances on the decisions that our U.S. attorneys make?
Yes, sir, I am, and I referred earlier to Robert Jackson's speech in the Great Hall of the Justice Department in 1940, and that's exactly the issue that he addressed, and I do agree with you that we do have significant power. Our assistant U.S. attorneys have significant power, and it's critical that they exercise that power responsibly.
Okay. Ms. Brandt, let me ask you a question. I'd like you to talk to me about you've had some experience in this area, about your personal philosophy on the intersection of national security and privacy.
Well, thank you, Senator Kennedy. That is a really important, critically important question that I have spent quite a bit of time thinking about over the last several years. I think it's hard to talk about it in the abstract, of course. Anytime the government is going to undertake, for example, a surveillance program in the national security context, it's critical for them to do within the bounds of law, but not just within the bounds of law, also within the bounds of what is appropriate from a policy perspective in terms of protecting privacy interests. I think it's possible to account for both interests in every case, but where that line is, it depends on the circumstances.
Okay. Well, doesn't the power of government scare you a little bit in terms of your privacy rights? Just you as a citizen.
I would say the power of government, I don't know if it scares me, but I view the power of the federal government to be considerable and potentially concerning in virtually every area, which is why it's important to have checks and balances, legal requirements, and frankly, oversight.
Do you
area
believe we have the proper checks and balances right now?
Well, again, Senator, that depends on the circumstances. I think in many areas, yes. Whether they always work correctly is another question, but I think the structure works well in the areas that I'm familiar with.
Okay. I want to thank you both for your willingness to serve.
Thank you, sir.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Congratulations to you both on your nominations. I'm going to ask Ms. Brand a question, and Mr. Rosenstein, you're free to space out on this one.
No.
Well, no, I just wanted to give him a moment to pause. Ms. Brand, can you comment on President Trump's claim about President Obama tapping his phones? Can a sitting president just order a wiretap or some other form of electronic surveillance? Is that how it's done?
Well, Senator, I can't comment on the comments because
Could you just answer my question? Is that how it's done? Can the president just order a wiretap?
Well, under FISA, Senator, the court order is required, but I don't know any of the facts that underlie this question, this current debate, so I'm reluctant to speculate on a hypothetical beyond that.
Okay, well, he has to get a FISA order, I believe, and I suppose if he were a cat burglar and went through the air conditioning ducts, he could have done it himself. Mr. Rosenstein, exactly 8 weeks ago, this committee held a confirmation hearing for the Attorney General, my former colleague Jeff Sessions. Now, Attorney General Sessions and I have very different views about a lot of things, but the purpose of a confirmation hearing is not to resolve differences of opinion on policy. The purpose of a confirmation hearing is to allow the American people to decide for themselves through our exchanges here in the committee whether the nominee is qualified to serve. But in order for the hearing to truly serve that purpose, nominees must answer questions honestly. That's why they swear an oath. But 8 weeks ago, my question was not answered honestly. I asked then Senator Sessions the following question: if there is any evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do? I didn't ask who had communicated with the Russian government. I asked how the man positioned to become the nation's top law enforcement individual, a man who had served as chairman of the Trump campaign's National Security Advisory Committee, would conduct himself if circumstances required that the Department of Justice investigate members of that same campaign. Here's what then Senator Sessions said, and I quote, "Senator Franken, I'm not aware of any of those activities. I have been called a surrogate at a time or two in that campaign, and I did not have communications with the Russians." Let me repeat that. I did not have communications with the Russians. As we all know now, that wasn't true. Attorney General Sessions met at least twice with the Russian ambassador in 2016, once in July, an event during the Republican National Convention, and once in September in a private meeting in his Senate office. But Attorney General Sessions did not acknowledge the fact that his testimony misrepresented the truth until the Washington Post published an article exposing his meetings with the Russian ambassador. In the 7 weeks between his appearance before this committee and the publication of that article, Attorney General Sessions had ample opportunity to come clean and correct the record, but that's not what he did. So after an embarrassing story in the Post describing undisclosed meeting with the very same Russian official whose communications forced the president's national security advisor to resign, Attorney General Sessions hastily called a press conference and announced that he would recuse himself from overseeing any Justice Department investigation into Russian interference with the election. So, Mr. Rosenstein, now that the Attorney General has recused himself, it's your turn to answer my question, the very same question. Again, here is the question I asked then Senator Sessions, and that I would like you to answer now. If there is any evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do?
If there is predication to believe that such a communication was in violation of federal law, Senator, I would ensure an appropriate investigation.
Now, Mr. Rosenstein, do you understand that you have an ongoing obligation to update your testimony and correct any inaccuracies or mistakes that you discover after you leave the hearing today?
You're making me very self-conscious, Senator, but yes, I believe I do. I'm trying to be as careful as I can.
Good. I must have just taken it for granted that witnesses understood their obligation to correct inaccuracies in their testimony, but evidently that obligation was not known to Attorney General Sessions. Yesterday, 4 days after the press conference at which he announced his recusal, and 55 days after his hearing, Attorney General Sessions finally wrote to the committee to update his testimony. In that updated testimony, the Attorney General references a letter written by the Democratic members of this committee on March 3rd. Attorney General Sessions said, and I quote, "The letter asks why I did not supplement the record to note any contact with the Russian ambassador before its disclosure. Having considered my answer responsive, and no one having suggested otherwise, there was no need for a supplemented answer." So it would seem that in the Attorney General's view, unless this committee has reason to believe that a witness provided false testimony, or unless this committee suggests that a witness's answer is grossly misleading or unresponsive, that witness is relieved of his or her sworn duty to tell the truth, the whole truth, and nothing but the truth. But I don't think that's how it works. And in light of Attorney General Sessions' failure to recognize his obligation to this body, I thought it was important for me to make sure that you clearly understand this obligation. And you do understand this obligation, right?
I believe I do, Senator.
Okay. I think Senator Sessions should come back. I think he owes it to this committee to come back and to explain himself. Because he also says in his letter, may I just... If you're making a statement to me, if you were asking him a question, you would have time to ask. I will not. This will be very short. He says, let's see, I did not mention communications I had with the Russian ambassador over the years because the question did not ask about them. I asked him what he would do as Attorney General if it was true that members of the campaign had met with the Russians. So he says, I did not mention communications I had with the Russian ambassador over the years because the question did not ask about them. He answered a question I didn't ask. And for him to put this in his letter as a response is insulting. And he should come back and explain himself, Mr. Chairman. I think he owes that to us. Because this appears to me like he was, and I've bent over backward, not to say that he lied. He needs to come back. I've bent over backward. I have given him the benefit of the doubt, but he has to come back.
Mr. Chairman, may I, may I just make one clarification, and I apologize, but Senator Franken's comments, I think, make it important for me to make this point. That is that I want to make sure I didn't misspeak earlier when I was asked about whether or not I would announce that an investigation was ending regarding Russia. I want to make sure you're all clear on this, that I do not know if there is an investigation. I don't know anything but what I've read in the newspapers at this point.
Well, I actually find it very disturbing that you did not read the declassified report on Russia's activities during the election. I find that very, very disturbing.
I read the newspaper story. I'm very, very sorry to hear that, Senator.
I would like to comment on what Senator Franken just said. And I don't expect Senator Franken to act like I would towards our witnesses, but as I remember Senator Franken asking his question of Senator Sessions, he referred to something that there had just been something come on CNN that obviously, and Franken said that Senator Sessions wouldn't know what it was, and he was going to take that into consideration, that it would have been all right for you to ask your question, and you probably should have given him a chance to get the information you had and reflect on it and give an answer in writing. Now, the way I tend to, and you both of you know that I said this to you when you were in the privacy of my office. If I was going to ask you
gotcha question, I was going to tell you about it ahead of time. And I consider what Senator Franken asked Sessions at that late moment that story just come out as a gotcha question. And
it was not a gotcha question, sir.
It was, from the standpoint that he didn't know what you were asking about.
But I said that as I was asking the question. I said you haven't heard this, and I don't expect that you have heard it.
Senator, tell us.
Look at the tape, Mr. Chairman.
Thank you,
please.
Mr. Chair. Congratulations to both of you for being here and to your families. A couple of questions. Very quickly, it's one I asked of the Attorney General nominee back not too long ago in the Obama administration. Mr. Rosenstein, this question's for you. The Government Accountability Office issued a report in December of 2014. I think it was titled, DOJ Could Strengthen Procedures for Disciplining Its Attorneys. Are you aware of that report?
Sorry, what year was that, Senator?
It was 2014, December.
I'm not sure I'm aware of that particular report. I'm aware of the general issue. I probably was aware of that report at the time.
Well, I would ask you in your capacity as the Deputy Attorney General to look at that report, because there's no evidence that I've been able to find since it was issued that there has been any actions taken to address the accountability problems, prosecutorial misconduct, and issues that were very clearly articulated in the report. I think there's a lot of information there that can increase accountability and professionalism within the DOJ. And I would like for you to maybe review that report and get back with my office if you think there are any things in your capacity that you would consider moving forward on or having merit. Because in my opinion, I don't think there's been any specific actions taken.
So, Senator, what I'd like to request, with your permission, is that I will commit to you that if I'm confirmed as Deputy Attorney General, I will not only read that report, but I'll talk with the Inspector General, because I think it's important for us to consult with the IG. They're right down the hall in the Justice Department, and make sure if they have advice about things we should do to better enhance the integrity of our prosecutors, that we institute those practices.
Thank you. Ms. Brand, I have a question for you. I think that it would be somewhere in your private sector capacity, you advocated for businesses, or you worked in an organization that has businesses as their members. One of the areas that the organization you were part of has advocated for immigration reform. One of the areas that we've discussed on this committee, I sit on the immigration subcommittee on judiciary, are the reputed abuses of visa worker programs. And I'm trying to figure out how we can get to the facts. If in fact, I'm one who actually supports immigration reform measures, because I think it's going to be important for this Congress, after 40 years of failures between administrations and Congresses, to solve a problem that's out there. One of them, I think, is maybe a misconception about the visa programs and their potential abuses. Do you have any insights into how we can actually get, through the U.S. attorneys or through others, to identify where legitimate abuses exist, so we can make examples out of the businesses that are preventing us from potentially make examples, if there are abuses out there, from preventing us to have an intelligent discussion about reforming the visa work programs?
Well, Senator, I think you're talking about my work at the Chamber of Commerce. I was a litigator. I was not in the policy.
Yeah, I was speaking more to your organization.
Yeah, I wasn't involved in that work for the Chamber, but I do know from my former government service that the visa programs there are a number of agencies involved in them: the Department of State, the Department of Homeland Security, in some cases the Department of Labor for certain worker visas. They're not administered by the Department of Justice. Although
it would be,
visa
I
fraud
guess what I'm trying to get to is we've got to have somebody own the problem. So I appreciate the answer. I want to be respectful of time. The thing is we've got to have somebody own presenting specific evidence of real abuses of the program, because I think there are more phantoms than reality. There are probably some, and in those cases, we need to make examples out of businesses. We need to up enforcement actions for businesses who are not adhering to the letter of the law. But we need to find somebody to own it. So if it's not the DOJ, then I need to go to some other agency and find someone who can identify these sorts of or these things that are actually creating additional challenges. Mr. Rosenstein, did you have anything to add on that?
My only thought, Senator, would be that there may be issues that are within the purview of the State Department and Homeland Security as well as Justice, but I would certainly, if I were deputy, provide any information we could to help you with that issue.
I think that would be very helpful. The next question I have also relates to immigration, and it's the immigration courts and the resources. We have a tremendous backlog that we need to address. To what extent have you studied this, and what could you offer me as some hope that we can get to a point to where we have more timely hearing and closing of cases through the immigration courts?
Senator, I haven't studied it. I'll let Ms. Brand answer as well. I haven't studied it, but I'm familiar with the issue, and what I can commit to you is that if I'm the Deputy Attorney General, it will be one of my priorities to make sure we move things as quickly as possible. So I understand that there is a backlog with regard to those cases, and I'll figure out whether or not there are procedural changes we can make or whether we need more resources in order to move those cases more quickly, because I think it's critical for the department, both in the civil and criminal context, to make sure we resolve those sort of matters as expeditiously as we can.
Thank you. Ms. Brand, do you have anything to add?
No, I think Mr. Rosenstein said it well. I know that during my former time in the Justice Department, there was a significant management challenge involved in finding the resources to address the incredibly high volume of immigration appeals. I don't know exactly where that stands now, but I would be happy to look at that if I'm confirmed.
And Mr. Rosenstein, my last question will be to you, and it has to do with state and local cooperation with the department in terms of public safety, justice and public safety. One of the areas here that we may have some disagreement would be in the areas of working with state and local law enforcement entities through task forces. I don't know if you're familiar with the issue that we've had over time with equitable sharing. I think there have been some abuses of it in terms of some seizures, but for the most part, I think it's a very important program to continue to ensure state and local participation. What are your views on that?
Yes, Senator. I have, in my capacity as U.S. Attorney, one of my priorities has been to work with state and local law enforcement in all contexts in determining where we should devote our federal resources, what are the significant crime challenges, how can we work together to address them, so it's not just a matter of the federal government bigfooting their way in and pushing local folks out of the way, but working together. And I think the equitable sharing program is a really critical part of that effort. So we need to make sure that if we're using that authority, we're using it appropriately, and we're using it consistently with federal law enforcement interests.
Thank you.
Thank you, Mr. Chairman. I'd like to start just by congratulating both of you on your nominations, and I'm thanking you for your long careers in public service and your families for their patience, persistence, and support, not just during your careers, but during this hearing. I'd like to start by simply adding that I agree with Senator Franken that I think the Attorney General should return to this committee and clarify his answers under previous questioning. I think it's important that we resolve the currently unresolved issues that I think were not clarified in his written response to this committee. Mr. Rosenstein, is it ever appropriate for the President or senior White House officials to contact the Department of Justice or the FBI with instructions or directions on how to conduct an ongoing criminal investigation?
If there are any contacts about ongoing criminal investigations, Senator, they should be directly with the Deputy Attorney General. I imagine there may be contexts, particularly with their national security equities or foreign affairs issues, where it might be appropriate in a particular case. The presumption is no, and only the deputy should be in position, in coordination with the Attorney General, to make a determination in any individual case whether there's an appropriate basis for an exception to that general rule.
The presumption is no. There should be limited and narrow contacts, and in no way should those contacts be designed to thwart, stonewall, or shut down an investigation that is well-founded in proceeding. Is that correct?
That's correct.
We spoke previously about your commitment to preserving the independence and public confidence in our law enforcement system. And I think your admirable record of public service and your personal testimony at the outset reinforces that. Given the unanimous opinion of our Intelligence Committee that Russia did in fact interfere in our election, and troubling evidence of actual contacts and even possible collusion between the Trump campaign and Russia, would you agree that it's vital to the assurance of confidence in our democracy and law enforcement system that any investigation into these matters be fair, free, thorough, and politically independent?
Yes, I do.
And you've stated previously that you'd be willing to resign if you felt that was not the case, that one of the things you would do if you felt you were inappropriately being pressured to shut down an investigation or the investigation was being stonewalled, that you would oppose those efforts. Is that correct?
I don't recall whether I said it here, but it's certainly true.
So in the steps before resigning, you would oppose those efforts at politically interfering. Will you commit that you would share with the American people, if you were compelled to resign under those sorts of circumstances, that that was the reason you resigned?
I think, Senator, I cannot answer that hypothetically. It would depend upon the facts and circumstances. In an appropriate case, I would. But I think I would need to. I'm a prosecutor, and generally speaking, we don't talk publicly about our cases, and I don't know what context it might arise in. So I can assure you that if it's lawful and appropriate for me to do it, I certainly would.
Thank you. Do you believe 3 to 5 million individuals voted illegally in the 2016 election, as our president has alleged?
Well, Senator, I have no independent basis of knowledge about that, and I'm not in a position to comment on it.
And how do you plan on using the resources of the Department of Justice to investigate alleged instances of voter fraud, either in the 2016 presidential election or other elections?
I anticipate, Senator, we'll continue to do it the way we have been doing it during the 12 years that I served in both the Bush and Obama administrations. When that sort of information came to the attention of our offices, we have attorneys in each U.S. Attorney's office who are trained in handling election fraud matters. They consult with experts in the Justice Department's Public Integrity Section who are responsible for election crimes. In appropriate cases, they would launch an investigation that may result in federal charges.
And do you agree with the Department's recent decision to withdraw from a voter ID case in Texas where just last year the Fifth Circuit concluded that the Texas law in question actually had a discriminatory impact on minority voters, and the Southern District of Texas is currently considering the evidence on whether Texas enacted the law with racially discriminatory intent?
I've read newspaper stories about it, Senator. I had no role in the department's original position or its revised position, so I do not know what the legal basis was or what, if any, determination was made by attorneys in the department. If I were in that position, I would make sure to consult with lawyers who understand those issues and reach an independent decision about the appropriate course of action.
Well, I was encouraged in your statement that corruption in civil rights cases are among our most sensitive and important. And it's my hope that you'll continue what has been your laudable record of public service in ensuring that public integrity cases and civil rights cases are appropriately and timely brought. Ms. Brand, if I could, the Office of the Associate Attorney General oversees, among other components, the Office on Violence Against Women. And you once criticized the Violence Against Women Act, which established and funds that office, and something which my predecessor, the former vice president, was quite proud of having a hand in enacting, as a, quote, broad expansion of federal criminal law, unquote. If confirmed as Associate Attorney General, will you support the Office on Violence Against Women continuing its current activities to reduce gender-based violence and protect victims?
Well, Senator Coons, I'm glad that you brought that up because that's an issue that's sorry, I think the microphone's on. Maybe I need to pull it closer. Is that better? That's an issue that's very important to me, actually. Chairman Grassley and Senator Ernst noted in their introductions that I serve on the board of directors of a nonprofit that, among other things, operates a domestic violence safe house and helps victims of domestic violence achieve independence and stability. So I absolutely support the work of the Office of Violence Against Women, and I would be honored to work with them.
Thank you, Ms. Brand. Forgive me. Mr. Rosenstein, if I might, we spoke yesterday at some length about your strong record of combating violent crime, pursuing public integrity cases, and protecting America's inventions and innovations through intellectual property enforcement. I'm especially interested in your view of the COPS office, COPS programs, and COPS grants as a tool for combating violent crime. And in my closing 30 seconds, would be interested in your view on how we might work together to strengthen state, local law enforcement cooperation with federal law enforcement, both in IP protection, we talked about Customs and Border, and in combating violent crime.
Yes, thank you, Senator. I look forward, if I'm confirmed, to working with you on both of those issues. With regard to IP, as you know, I've been involved in the department's, the Attorney General's Advisory Committee with regard to intellectual property issues. So I'm familiar with those issues, and we brought some significant cases in my district, and I'm committed to continuing that work. With regard to the COPS office and combating violent crime and working with police agencies, I don't know all the details of it. My interaction with the COPS office was limited to one incident or one episode in which they came to Baltimore and initiated a COPS investigation. And I think it certainly can be a useful tool in an appropriate case. So I anticipate that we would use that authority as we would all others to try to work with and help improve state and local law enforcement.
Thank you both. Thank you, Mr. Chairman.
Well, that's all right, Senator. Thank you.
Thank you, Mr. Chairman, and thank you for the testimony. And I apologize if I'm covering something that was been covered before. I haven't been able to be here the whole time. But Mr. Rosenstein, we talk about an aspect of immigration that's important in the state of Arizona. We've had something along the southwest border called Operation Streamline that has been, the purpose of the program is really to cut down on illegal border crossings by adopting a no-tolerance posture there for those who are entering the first time and re-entering illegally. It's helped increase border security, particularly along the Yuma sector. Have been very effective there. Nevertheless, in recent years, the U.S. Attorney's Office for the District of Arizona adopted a policy that ended prosecutions for first-time crossers. And I've asked many times Attorney General Holder and Attorney General Lynch, and I was never able to get a straight answer as to why this program had ended. I want to make sure that that it is enforced. We've had success, and I don't know why with a successful program along the border that we would adopt another posture. I hear from sheriffs along the border all the time how effective that was, and that when the federal government doesn't do this, then the burden falls to them. So can you talk about Operation Streamline, your understanding of it, and if DOJ plans to go forward under your and others' leadership?
Well, Senator, as you know, Maryland doesn't have an international border, and I'm not familiar with the Streamline project. As a general proposition, though, I agree with you that law enforcement can be an important tool, among other tools available, to combat immigration crimes and all other crimes. So if I become the Deputy Attorney General, I certainly would consider that an important issue to review and consult with the U.S. Attorney in your district and any other districts as to what their policies are. As a general matter, we do have limited resources, and we do need to make decisions about which cases to bring, but I don't think we should rule out any cases categorically if there's a potential to have a deterrent impact by prosecuting those cases.
What has happened is Yuma effectively had Operation Streamline. Border crossings went down significantly there. Tucson sector never adopted it, and it pushed illegal crossings toward the Tucson sector. And so when we have uneven application of the law, it has impacts on those border communities. And so I would hope that you'd move forward with regard to Operation Streamline. When I ask Attorney General Sessions about it, he's obviously familiar with it and committed to move forward, and I hope the department will do so. With regard, let's switch to the subject for a minute of DOJ grants. Fiscal year 2009 through 2013, department awarded approximately $17 billion in grants. I'm concerned about the possibility and some of the findings of waste and fraud within these grant programs. It was recently reported that DOJ had squandered as much as $100 million in taxpayer dollars over the last 5 years. Recent OIG audit questioned nearly all of more than $23 million in grants awards to, just for example, the Big Brothers and Big Sisters of Arizona, or I'm sorry, of America. As the department's Inspector General Michael Horowitz said before the House Judiciary Committee, there's virtually no visibility on how grant funds are actually being used by the recipients. He continued, unless there is an OIG audit or investigation or the granting agency dedicates resources to collect and analyze accounting information from the recipient, the government and the taxpayers are virtually in the dark regarding how grant funds are actually used. This is a serious problem. What does the department plan to do to make sure there's more transparency and that we know how these grant funds are being utilized?
Senator, in my capacity as U.S. Attorney, I frequently work with Inspector Generals for the Justice Department and for other agencies, and there are a variety of tools that we have available to us to ensure that those grant funds, if they're not used appropriately, that we take appropriate remedial action. One of them is civil enforcement, and in fact, we have the ability to file False Claims Act cases.
All right, folks, thank you very much. Make sure to click the link in the description below for Sean Spicer. I'm going to shut this stream down. The Sean Spicer stream is going to go up and, right after that. So don't go anywhere. Click the link in the description. I'll also put it on the chat for Sean Spicer. It's starting pretty soon. So don't forget to go over there and get on the chat. The chat will continue on that one, and we'll start the Sean Spicer press briefing that is starting soon. Like I said, click the link. Sean Spicer is coming very soon, and I'll see you guys on that chat in just maybe 2-3 minutes. So if you are new to our community, hit that subscribe button, that bell, and it will give you a heads up when we go live in just a few minutes, in case you guys don't find it or however it is, because it's kind of tricky. So click on the link. And I'll see you guys in 2 minutes on the other chat. Thank you very much.